Good afternoon and welcome to the weekly business meeting of the South Carolina Public Service Commission. Today is Thursday, April 3rd, 2025. It's approximately 1 p.m. Before we begin, would you please join me in a moment of silent reflection? Thank you very much. All commissioners are present in the hearing room. Mr. Scarborough, would you please proceed?
Yes, sir. Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the next regularly scheduled business meeting. Staff recommends that the next Commission business meeting be set for Thursday, April 10, 2025 at 1 o'clock p.m.
The next business meeting will be April 10th, 2025 at 1 o'clock.
Thank you, sir. Today we have 7 items on the utilities agenda and 18 items on the transportation agenda. Items numbered 1 and 2 on the utilities agenda are similar and the Commission can address them together. Item number A1 is in docket number 2008-140A. This is a request from Kiowa River Utility Company Incorporated for an extension of time until May the 1st, 2025 to file its annual report. And item number 2 is in docket number 2008-140A. This is a request from Defusky Island Utility Company Incorporated for an extension of time until May the 1st, 2025 to file its 2024 annual report.
Thank you. Having heard items 1 and 2 as presented by Mr. Scarborough, is there a motion?
Chair Powers, I'd like to make a motion.
Commissioner Caston, you're recognized.
I move that the Commission grant the request for a 30-day extension of time until May 1st, May 1st, 2025 for the utilities identified by Mr. Scarborough on utility items number 1 and number 2. A directive order will be issued in each respective docket, granting extension of time to file such annual water and wastewater reports no later than May 1st, 2025. So move.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is there any further discussion? Hearing none, all those in favor signify by saying aye.
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 Those opposed by no, the ayes have it. The motion carries.
Item number 3 is in docket number 2025-80WS. This is a motion from Jacob Utilities, LLC for confidential treatment of supplemental Exhibit A to its application.
As to item number 3, is there a motion?
Chair Powers,
Commissioner Thomas.
I move that the Commission grant the request of Jacob Utilities for confidential treatment of certain information in its supplemental Exhibit A. I further move the Commission find the confidential version of supplemental Exhibit A contains proprietary, confidential, commercially sensitive financial and trade secret information. Jacob Utilities specifically states that the charges and fees charged by Goldie and Associates Incorporated and Greenstone Construction, LLC, to Jacob are highly confidential. The public disclosure of these costs and analysis would negatively impact Jacob Utilities, its shareholders, and members. Jacob Utilities asserts that the financial information meets the definition of trade secret defined under South Carolina Code Annotated Section 39-8-25A to exclude such information from public disclosure and from disclosure under the Freedom of Information Act. SC Code Annotated Sections 30-4-10 et seq. I further move the Commission find that this information is exempt from disclosure under the Freedom of Information Act and from public disclosure by the Commission as a public record pursuant to Regulation 103-804S2.
Thank you, Commissioner. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 4 appears in docket number 2024-18E. This item involves final disposition of Santee Cooper's 2024 Integrated Resource Plan update.
As to item number 4, is there a motion?
Mr. Chairman,
Commissioner Belser.
thank you. Mr. Chairman and fellow commissioners, based on the 2024 IRP update as filed by Santee Cooper, the ORS report entitled Review of the South Carolina Public Service Authority's 2024 Integrated Resource Plan Update, comments received from the intervening parties, South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Sierra Club, and filings made in this docket, I move that the Commission accept the 2024 Integrated Resource Plan Update filed by the South Carolina Public Service Authority, or Santee Cooper, as reasonable and meeting the statutory requirements established by Act Number 62, enacted in 2019, and Act Number 90, enacted in 2021. I also move that the Commission finds Santee Cooper's IRP update complied with all requirements for the 2024 IRP update as set forth by the Commission in Order Number 2024-171. In accepting the 2024 IRP update, I move the Commission finds that Santee Cooper shall address the following recommendations made by the Office of Regulatory Staff and agreed to by Santee Cooper and the Stakeholder Working Group, and in future IRPs or IRPs updates as specified herein. Number 1, Santee Cooper shall continue to provide updates regarding its plans for the cross-generating station retirement evaluation and associated transmission evaluations, as well as the results of the study in support of the 2026 triennial IRP in the Stakeholder Working Group. Number 2, Santee Cooper shall continue to monitor hydrogen availability and discuss price forecast assumptions with IRP stakeholders in the Stakeholder Working Group prior to the 2026 triennial IRP. Number 3, Santee Cooper shall continue to discuss updates related to the Inflation Reduction Act and Infrastructure Investment and Jobs Act incentives in the Stakeholder Working Group. Number 4, Santee Cooper shall perform production cost model benchmarking studies of its Encompass model in conjunction with its comprehensive IRPs and discuss the results in the Stakeholder Working Group. Number 5, for future IRPs and IRP updates, Santee Cooper shall monitor, track, and report annually the forecasted versus actual load consumption for economic development load. Number 6, Santee Cooper shall update its GHG rule portfolio modeling assumptions in the 2025 IRP update to reflect the latest EPA guidance available at the time the modeling is performed. Santee Cooper shall discuss changes to its assumptions based on changes to the GHG rule in the Stakeholder Working Group prior to the 2025 IRP update. Number 7, Santee Cooper shall provide updates in future IRPs and IRP updates regarding the planned solicitation for a battery energy storage system of up to 300 megawatts of 4-hour duration, which, according to Santee Cooper's reply comments, would be sited at the Jeffries Generating Station to leverage existing interconnection capacity and the Energy Communities Tax Credit bonus per the Inflation Reduction Act. Number 8, in advance of future IRPs and IRP updates, and as required by South Carolina Code Annotated Section 58-27-40A3, Santee Cooper shall continue to host the Stakeholder Working Group. Further, Santee Cooper shall provide updates to the Commission about the activities of the group and Santee Cooper's plans to incorporate lessons learned into future IRP filings. Number 9, Santee Cooper shall discuss its plans to prepare the next market potential study in the Stakeholder Working Group ahead of the market potential study update in 2025. Finally, I move that any order provisions from previous Santee Cooper IRP decisions issued by the Commission that have not already been addressed by Santee Cooper be incorporated in any ongoing stakeholder engagement, potential negotiations, and in its 2025 IRP update. The Commission will issue a full order detailing its decision in this matter. Thank you, Mr. Chairman.
Thank you, Commissioner Belser. Having heard this motion by Commissioner Belser, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
And those opposed by no. The ayes have it. The motion carries.
Mr. Chair, item number 5 has been deleted from today's agenda. So moving on to item number 6, which appears in docket number 2019-326E. This item involves establishing a procedural schedule related to the joint application of the Phase 2 modifications to the South Carolina Generator Interconnection Procedures.
As to item number 6, is there a motion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, I move that the commission direct the chief clerk to establish a procedural schedule to request comments from interested stakeholders concerning the joint application filed by Duke Energy Carolinas LLC, Duke Energy Progress LLC, Dominion Energy South Carolina Incorporated, related to approval of Phase 2 modifications to the South Carolina Generator Interconnection Procedures. I further move that the procedure schedule include May 6, 2025 as the deadline for interested stakeholders to file their comments on the joint application, and June 6, 2025 as the deadline for joint applicants to respond to filed comments. I further move that the commission decide this matter without an evidentiary hearing no later than July 7, 2025. Finally, I move that the chief clerk be empowered to adjust to the procedural schedule as necessary for good cause shown by the parties. So moved.
Thank you, Vice Chair Williams. Having heard the motion by Vice Chair Williams, is any further discussion?
Chair Powers.
Commissioner Williams.
Thank you. Vice Chair Williams, I wonder if you would consider an amendment.
I welcome hearing it. Yes, ma'am.
Okay. I appreciate your motion, and I've learned a lot in talking with you about this. As you and I discuss over time, we talk a lot about good government, and I applaud the idea of us having an internal goal for when we make a decision. And I believe that's very important, and it's important to all parties, but I am concerned about identifying the July 7th, that we make a decision by July 7th. So my proposed amendment is that we keep that sentence in, and it read, I further move that the commission decide this matter without an evidentiary hearing, period.
Okay.
It leaves us free to meet that deadline that you have identified, but does not obligate us, given the complexity and the unknowns that may come between now and then. Thank you for your consideration.
Okay. Would you mind sharing those concerns? What are the concerns about including a hard date?
Well, in other dockets, I've made a similar decision that, to me, I think there are two layers to it. One is, I think that if you and the chair want us to identify those regularly and consistently, that we could do that, but we would need a really thorough analysis of what was achievable. And what I have seen time and time again in my experience here is that we think we know what may happen in the next 2 or 3 months, but unknowns, surprises, unforeseen circumstances emerge. I agree that having an internal goal is very important. I want us to make that goal, and I want us to be confident we can make that goal. And I think that that is something you and I share in common from our perspective of being the best public servants we can be. But I don't know that that goal has to be, until we are ready to do that kind of more uniformly and more exhaustively, I'm not comfortable supporting that in this particular motion.
Thank you. There's a American poet by the name of Nas who wrote a poem in the early 90s entitled "If I Ruled the World," and he goes on to talk about things he would do if he ruled the world. Obviously, neither Nas nor I rule the world, but if I ruled the world, I would like to see a public service commission that could set targets and meet them. I believe that we can, particularly on this case. When I look at the application, the 32-page application that was filed by the joint applicants, what I see is an exhaustive process that they went through to produce the Phase 2 modifications and revisions to SC GIP or GIP. How I don't know how we're saying that now. And so in this case, I think 30 days for the commenters to file any comments if they have them, 30 days for the joint applicants to respond, and in turn, 30 days for the commission to reach a decision is more than fair considering the information that we have now and how the information will be filed with the commission, and we can have the opportunity to read the comments and the responses as they're filed. Due to unforeseen circumstances that always seem to arise, I think empowering the chief clerk to adjust the procedural schedule is the fix for that. And for that reason, those targets, I'm comfortable with those targets because due to unforeseen circumstances that may arise for the parties, or even, hopefully not, but even for the commission, we still have a pathway to, I guess, request an extension, if you will. And so I respect your amendment, but if I ruled the world, this is the path forward that I would take, and that's what I'm offering to you and the rest of my colleagues. Thank you.
Chair Powers.
Chair Powers.
Mr. Williams,
Chair Powers, may I make a substitute motion?
can we hear the questions first?
Yes.
If,
Mr. Caston?
you know, having heard that back and forth, and I certainly understand Vice Chair Williams, the things you're saying, and I think they're laudable. But from my perspective, I really don't see the wisdom of a date. But what I do agree with, and I don't want to put words in your mouth, but I think you have a similar attitude, is that as a whole, PSC, you know, we just do our job well. Do what we're supposed to do the right way. The outcomes and results speak for themselves. And if the outcome and results are such that they don't meet our expectations, then that's on us. That's something, you know, we should deal with. I have no problem with the motion, but I do have a problem with the date. I don't think it's necessary, and I don't think it's wise. But I'm assuming from, if you could rule the world, that you would keep it in. But since you know you can't rule the world, are you amenable to that amendment, or was that a hard no? I guess that wasn't clear to me.
It's a respectful no.
Understand.
As respectfully as I can say the word no. I would ask a question, considering the deadlines for comments and the deadlines for responses. What's the difference between the uncertainty that exists for the commenters and responders and the uncertainty that exists for the commission?
Personally, I'm not fearful of really any date. I mean, you know, the staff, I can't speak for them. You know, they certainly know their schedules better than I do, but I think as far
Are
as...
you referencing our staff, the commission staff?
Yes. Yes, but relative to, you know, the desire to do things in a timely manner, I fully support. To do things effectively and efficiently, without question, I support. And I have no reason to doubt that anything before or near that date or whatever is unachievable. I have no reason to doubt that. My only point of difference is I do not think we should put a date. I mean, simple as that. I see I think that's all I need to say about that. But thank you, Vice Chair.
Vice Chair Williams, may I ask a question?
Yes, sir.
It's my understanding from what you said that if there is a problem or something arises, that the chief clerk can make a change in this schedule. That would include this date of July 7th, would it not?
Yes, sir.
Okay.
What this does is set an outline that it sets an outline, I guess, perfect case scenario, and then fully empowers the chief clerk to adjust as necessary.
And I think you said that the parties could make such a request. Could the commission itself make that decision, whether there's a request or not, to change the timeline?
Yes, sir.
I just didn't quite hear that. I didn't want any motion or any decision to be limited to the parties having to make that motion. If we need to do it, then I think we should have that right, and maybe that language is missing in there.
Chair Powers.
Commissioner Thomas.
Thank you. I just have a question. So part of the motion contained the phrase that the commission decide this matter without an evidentiary hearing. And I just wonder how we know today that we will not want an evidentiary hearing. If anybody can help me on that, then I'd appreciate it.
Mr. Chair,
Yes, sir, Vice Chair.
I can't speak for my colleagues, Commissioner Thomas, but for me, the application, first of all, the entire docket, the 11 joint progress reports that were filed, the application highlights several large stakeholder engagement meetings with over 100 participants at those meetings, presentations given by some of the interveners, including Sasiba and Alder Energy. In addition to the fact that the joint applicants filed this application on March 7th, approximately a month ago, making the request for a decision to be made without an evidentiary hearing and for comments to be filed in lieu of pre-filed testimony. With that being, and all the interveners were noticed, and so with that being out there, the application being out there for approximately a month, and considering all the work that has been put into this project up to this point, based on my review and standing on, I believe it's Regulation 103, I'm blanking, 103.817, I think C2, the commission is empowered to make a determination as to whether or not an evidentiary hearing is necessary, or whether or not, or if I should say, the commission can rely on the filings. And for me, I can rely on the filings, and I think that I can make a decision based on the comments. Now, obviously, that wouldn't be the case for every matter that comes before the commission, but for this one, I feel comfortable there, based on the work that has been done up to this point.
Thank you. I appreciate that.
Thank you, Vice Chair. Commissioner Williams, do you still have a substitute motion?
I do. First, I'd like to answer a question Vice Chair Williams asked, if that's okay.
Certainly.
Okay. You asked what's the difference between a deadline for the commission and a deadline for the various proceedings. And I think we have a standard of working with the clerk to identify and adjust the proceeding deadlines, and it's how, as you know better than me, how the complicated and the intensive information is compiled and shared, and we've got a track record of doing that, and the ability for the director, the clerk, to talk with the parties when needed about any adjustments in those deadlines. As I said earlier, I feel like this is a new frontier for the commission to make a public decision about when we want to make a deadline. And for a decision. And I want to do that right and well, and I'm not wanting, I understand the particularities, the special circumstance of this particular application, but I am just not comfortable with that particular motion. In addition, I understand why July 7th is identified. It happens to be, just after the 4th of July and times when people are away, and it happens to be just after a fairly significant docket that we're going to be considering. And my concern is more, is broader than that, but when I look at the specificity of it, I don't feel it's in our best interest to put this out there. Although I know our clerk can make good decisions with regard to that, I just feel like we're making a new tactical decision, and it doesn't feel like this is the right time and place to do it for me. So for that reason, I have a substitute motion.
If you would present the motion.
Okay. Vice Chair Williams offered a motion, and perhaps for the record, it's best that I read that again, but I am just removing 3 words and 4 words and some numbers. So Vice Chair Williams, I believe you made this motion. I move that the commission direct the chief clerk to establish a procedural schedule to request comments from interested stakeholders concerning the joint application filed by Duke Energy Carolinas LLC, Duke Energy Progress LLC, and Dominion Energy South Carolina related to approval of Phase 2 modifications to the South Carolina generator interconnection procedures. I further move that the procedural schedule include May 6, 2025 as the deadline for interested stakeholders to file their comments on the joint application, and June 6, 2025 as the deadline for joint applications to respond to filed comments. I further move that the commission decide this matter without an evidentiary hearing, period. Finally, I move that the chief clerk be empowered to adjust the procedural schedule as necessary for good cause shown by the parties. I so move.
Thank you, Commissioner Williams. Is there any further discussion on the substitute motion? Hearing none, in this case, I think we'll have a roll call vote, beginning with Commissioner Williams.
Aye.
And this is on the substitute motion, correct?
Yes, correct.
Thank you. I vote no.
Mr. Caston,
Aye.
Mr. Thomas,
Aye.
Vice Chair Williams,
I vote no.
and I vote no, the motion fails. Which brings us back to the original motion. We'll do a roll call vote on that as well, beginning with Vice Chair Williams.
I vote aye.
Commissioner Williams,
This is one of those moments I don't like this particular job. I'm 95% yes and 5% no, and I think that means I'm a no. So that is a no.
all right. Commissioner Belser,
I vote yes.
Mr. Caston,
No.
Mr. Thomas,
Yes.
and I vote aye, the motion carries.
Item number 7 appears in dockets number 2025-16E and 2025-17E. This is a request from Duke Energy Carolinas LLC and Duke Energy Progress LLC for confidential treatment of certain portions of informational reports filed regarding avoided cost.
Having heard item 7 is presented by Mr. Scarborough, do I hear a motion?
Chair Powers.
Commissioner Caston,
Thank you. I move that the commission grant the request of Duke Energy Progress LLC and Duke Energy Carolinas LLC for confidential treatment of certain portions of informational reports filed regarding avoided costs. I further move that the commission find that the confidential version of these informational reports on avoided costs contains proprietary, confidential and commercially sensitive and financial cost information of a nature that, if disclosed, could negatively impact Duke Energy Progress LLC, Duke Energy Carolinas LLC, its shareholders, and customers. Such information contained in the informational reports to be protected reflects the company's cost to procure additional energy and/or capacity. Companies assert the need to protect from public disclosure their projected and actual cost to procure such energy capacity, or both, to prevent a non-competitive impact. Duke Energy Progress LLC and Duke Energy Carolinas LLC assert that this information described above must be excluded from public disclosure as a public record and from disclosure under the Freedom of Information Act, South Carolina Code, annotated sections 30-4-10. I further move the Commission find that this information is exempt from disclosure under the Freedom of Information Act and that it is exempt from public disclosure by the Commission as a public record pursuant to Regulation 103-804, subparagraph S2. I so move.
Thank you, Commissioner Caston. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. So moving on to the motor carrier agenda. In Part A, we have 14 applications for new Class C certificates that the commission can address together. Item A1 is in docket number 2025-91T, which is the application of the Van Man LLC for a Class C charter certificate. Item A2 appears in docket number 2025-92T. This is the application of Gentle Journey Transit LLC for a Class C non-emergency certificate. Item A3 is in docket number 2025-93T, which is the application of CO Medical Transportation for a Class C non-emergency certificate. Item A4 is in docket number 2025-94T. This is the application of 4 Points Limousine LLC for a Class C charter certificate. Item A5 is in docket number 2025-95T. This is the application of Luxury Limousine Services LLC for a Class C charter certificate. Item number 6 appears in docket number 2025-96T. This is the application of Assured Transit LLC for a Class C charter bus certificate. Item number 7 is in docket number 2025-97T, which is the application of Roland West LLC for a Class C non-emergency certificate. Item number 8 is in docket number 2025-98T. This is the application of Surfside Taxi LLC for a Class C taxi certificate. Item number 9 appears in docket number 2025-99T, which is the application of Limo Times in Myrtle Beach LLC for a Class C charter certificate. Item number 10 is in docket number 2025-100T. This is the application of Professional Development and Training Services LLC for a Class C charter certificate. Item number 11 appears in docket number 2025-102T, which is the application of Roper St. Francis Ancillary Services for a Class C non-emergency certificate. Item number 12 is in docket number 2025-103T. This is the application of Adania Echeverria Hernandez, doing business as Happy Transportation Lachido for a Class C taxi certificate. Item number 13 appears in docket number 2025-104T. This is the application of Beyond Care Transportation LLC for a Class C non-emergency certificate. Finally, item number 14 is in docket number 2025-105T, which is the application of Jason Kelly Transportation LLC for a Class C charter certificate.
Thank you. As to items number A1 through A14, is there a motion?
Chair Powers.
Commissioner Thomas.
Thank you. I move that the Commission approve the applications for Class C certificates in item numbers A1 through A14 as identified by Mr. Scarborough. A directive order will be issued for each application in the respective docket.
Motion has been made by Commissioner Thomas. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
In Part B of the transportation agenda, there is one request to withdraw and amend an application. Item B1 is in docket number 2025-85T. This is a request from Island Hopper Taxi LLC to withdraw its application for a Class C taxi certificate and for approval of its amended application for a Class C charter certificate.
As to item B1, is there a motion?
Chair Powers.
Commissioner Caston.
Thank you. I move that the commission grant the request of Island Hopper Taxi LLC to withdraw their original application and that the commission accept the filing of applicant's amended application correcting the type of Class C certificate to a Class C charter certification. Excuse me. I further move that the commission approve the amended application of Island Hopper Taxi LLC for a Class C charter certificate. Class C charter certificate grants the Island Hopper Taxi LLC the authority to provide motor carrier service as follows: between points and places in the state of South Carolina, restricted to 7 passengers. I move the commission find that Island Hopper Taxi LLC is fit, willing, and able to provide the service to be published to the public as requested. I move the commission find a certificate should be issued by the Office of Regulatory Staff to Island Hopper Taxi LLC upon compliance with South Carolina Code annotated Section 58-23-10 as amended and the applicable regulations for motor carriers. South Carolina Code annotated regulations, Volume 10, 2012 as amended, and the requirements listed in Exhibit A, which are attached to this directive. I so move.
Thank you, Commissioner Caston. As to item B1, we've heard the motion by Commissioner Caston. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
In Part C of the transportation agenda, there is one request for reinstatement of a certificate. Item C1 appears in docket number 2011-368T. This is a request for expedited consideration for reinstatement of Class C taxi certificate number 8476.
As to item C1, do I hear a motion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, I move that the commission grant the request of Aiken Taxi Transport LLC for reinstatement of its Class C taxi certificate number 8476. The motor carrier's Class C taxi certificate number, 8476 was revoked by order number 2025-28 on February 5th, 2025. The Office of Regulatory Staff has verified by letter dated March 27th, 2025, that Aiken Taxi Transport LLC has insurance coverage and proof of insurance is received. The Office of Regulatory Staff will reinstate the motor carrier's Class C taxi certificate number 8476. So moved.
Thank you, Vice Chair Williams. Having heard the motion by Vice Chair Williams, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
In Part D of the transportation agenda, there are two requests for extensions of time. Item D1 is in docket number 2025-56T. This is a request from iRide Transit LLC for a 12-month extension of time to comply with Commission rules and regulations.
Item D1, is there a motion? Commissioner Belser.
Thank you. On March 6, 2025, by order number 2025-117, iRide Transit LLC was approved for a Class C non-emergency certificate following compliance with Commission rules and regulations. Order number 2025-117 allows 90 days for the carrier to complete the certification process, which includes complying with the requirements of filing proof of insurance, payment of license fees, and other information required by law. A carrier may also request additional time to come into compliance beyond the 90 days allowed by the order approving the carrier's application. iRide Transit LLC filed a request for a 12-month extension on March 19, 2025 to come into compliance with Commission rules and regulations. I move the Commission grant the request of iRide Transit LLC for a 12-month extension of time from the date of approval by the Commission, which is March 6, 2026, to comply with Commission rules and regulations required to operate and use a Class C non-emergency certificate. Prior to the expiration of this extension period ended on March 6, 2026, iRide Transit LLC must come into compliance with commission rules and regulations, or may, if applicable or available, seek other relief from the commission, such as the filing of a new application with current or updated information. So moved.
Thank you, Commissioner Belzer. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it, the motion carries.
Item D2 appears in docket number 2024-337T, which is a request from Southern Charm Limos LLC for a 3-month extension of time to comply with commission rules and regulations.
As to item D2, do I hear a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the commission grant the request of Southern Charm Limos LLC for a 3-month extension of time, which is until June 19th, 2025, to comply with commission rules and regulations required to operate and use a Class C charter bus certificate. Prior to the expiration of this extension period ending on June 19th, 2025, Southern Charm Limos LLC must come into compliance with commission rules and regulations, or may, if applicable or available, seek further extension or other relief from the commission.
Thank you, Commissioner Williams. Having heard the motion by Commissioner Williams, any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it.
Mr. Chairman and Commissioners, this concludes all business noticed before the commission today.
Thank you, Mr. Scarborough. Thank all who have joined us. I'd like to take a privilege at this point in time and wish a very happy birthday to our own Commissioner Williams, who I think just recently suffered a birthday this week. And with that, have a great rest of your day. We are adjourned.